Okay, I think we should start. Chetna, can you confirm if I'm audible and visible, and if somebody from the audience can also confirm maybe on the live chat window? Can you please help me know if I'm visible and audible to all of you? Okay. All right. So let me display my presentation to all of you now. Okay, hi everyone, and I'm very happy to see you all online. It's 9 p.m. in the night, but this shows that how much importance you pay to your preparation for patent agent examination. Hi Vinita, hi Ritvik, Nimi, Makrant, Dr. Pushottam, Vijay Lakshmi, everyone. I'm very happy to see you all here. So today, what we are going to do is that we are going to talk about some of the questions from the past year question papers with an intention to brainstorm because, like I said, last Sunday video when we did on how to crack patent agent examination, what came out was that while it may not be very difficult to crack paper one, but for paper two, it might be a bit difficult. Why? Because these are value based questions. These are the questions which are subjective in nature, and it requires articulation, a certain sort of assumption that you have to make. So, keeping that in mind, we will take some four questions today, two from 2010 question paper, one we will take from 2013 question paper, and one from 2016. So before we really get into the today's discussion, I was just reviewing past year exam results. I was looking at 2013 and 2018 exam results. Those who failed in the exam, I was looking at the numbers that they achieved. What was seen is that there were very less marks that they were able to fetch in paper two. I think it was close to 50, sometimes 49, sometimes close to 60, but it was very difficult to see anybody who may have achieved beyond 60. And there were answers, I mean, for paper one, it was similar number, around 60 or 55. So as a result, they were not able to make that 150 marks out of 250 because that is the total aggregate 60% that one has to achieve. So they had to sit for the viva, and in the viva, people were they were able to just receive let's say 20 marks, 30 marks, and therefore it could not they could not complete it with 150 marks overall. So with today's presentation, what I'm going to give you some strategies as to how to read a question in the question paper, and then also try to understand that how to answer it. See, what happens is that all of us are from the science and engineering and technology background. Unlike from law background or some other domain, the difference between the two set of people is that for us, we are always very to the point. We just write very brief, in very brief. And there are some people who would end up writing essays. Here in cracking patent agent examination, especially paper two, we have to be in the middle of the both. We cannot be very crisp and we cannot be just to the point, because otherwise we will not be in a position to explain to the examiner who is checking our question answers. And we cannot end up writing essays, because if we do that, then it means that you are losing your essential time, which you should wisely utilize. So let's go with this background further ahead. One disclaimer to all of you. Today's discussion is primarily only for academic purposes. Please do not consider this as any sort of a legal advice. So it's purely to help aspirers to prepare for the exam. And one more request, that please be very live on your chat. Make me feel that you are all up and listening to me very properly. And so let's go ahead with it. So paper 2, how to fetch good marks. I think before we get into the real questions and understanding how to solve them, first let us identify some of the basics that you all must know. The basis of the marks and the length of your answers. As to there are some many people who ask me in the class as to how what should be my word limit. If it's a 5 mark question, should I write one full page or half a page? And if it is a 10-mark question, should it be two to three pages or what? So I would say that it completely depends on the kind of question that you are getting and what examiner is asking you to do. Especially also look at the marks that are assigned. Like if it is 5 marks, I think half a page should be good enough. If it is 10 marks, one page with some flowchart should be good enough. The second thing that you must remember is that you have to sometimes make assumptions in order for you to be able to answer your question effectively, because examiner cannot give you all the facts. He's just trying to understand what your understanding is with regard to the key concepts. So when you read a question, you can pull your horses of your brain and start presuming certain things. You can be more imaginative once you do that. And therefore this image that you see, वो दिमाग की बत्ती खोलने वाला चीज है कि when you read the question paper, you have to open up the bulb of your mind and you can think about so many variety of things, and start assuming certain situations. And as we go and progress to getting into the question, I think I'll be able to better explain what I mean with this point number 2. Third is write in bullets. Okay. For example, sometimes people have a habit of writing in paragraphs. In the paragraph, for a reader, it becomes very boring to then read it in one go. But if you put paragraphs in the form of bullets, like point number 1, point number 2, point number 3, then it makes it very easy for the reader and to give you better marks, because the person who's reading your answer knows that okay, this one point was related to something. Now it's over. The writer has now the candidate is now ready to give answer to some more concepts. So therefore numbering is very important. Always give your answers in numbers, like 1 2 3 4. Put that in bullet. Don't get into a paragraph writing, don't get into a essay writing. Fourth is mention sections and rule along with the required fee. um, Sometimes people might think, okay, let me just write without giving sections, that's not important for them. But that would be a myth. It's not correct. Whenever you write your answers, because see, when you are taking an exam, you are actually uh, you are doing it basis your understanding of the patent law. So you have to support your arguments, whatever you are giving as an answer. You have to support it with certain sections and the relevant rules, and always provide a fee. Like in the last Sunday's webinar, I told you that it may not be very easy for a human brain to remember all the fee, because Schedule 1 of the Patent Act lists a lot of fees for different steps. Uh, if you are not able to memorize all of it, at least the key you should be able to memorize. And just for the sake of it, if you forget it while writing the paper, just say that the fee as per the schedule 2 or fee as per mentioned in schedule 1 of the Patent Act. Okay, let's go ahead and start with the question 1. This is the question from 2010. It was a 5-mark question. And so let me read out the question to you. Y owns a Indian patent. Okay, so there is a patentee who owns patent already. It's a granted patent. X requests for a license under the patent from Y. Y imposes certain conditions such that X cannot acquire such articles which are not covered by the patent from any person other than Y. Y also imposes a condition of exclusive grant back on the license. As an agent, do you think that these conditions are appropriate? Please give your answer vis-a-vis the relevant provisions of the Patent Act. So there, if you look at the last line, here the examiner, here the paper setter is already asking you that, guy, whatever you state, you please put and support your argument with regard to the relevant provision in the Patent Act. Okay. Now, before I go to the facts and what is already mentioned, I think a clear ask is that Y owns a patent. X is a prospective licensee who needs a license. Y is ready to give a license. However, he wants to impose certain conditions. What are the two conditions? So here are the facts written. Whenever you read a question, start penning down in your rough paper as to what are the facts already provided and if there is any assumption that you are required to make. So let us look at the facts. One of the restrictive condition that is being asked here to put up in the license is to purchase even non-patented articles from the patentee itself. So which means if I as Sheetal Chopra wants to give you a license, let's say to Vinita Kumari, and she says, okay, Sheetal, give me license to your invention, and I'll say, okay, Vinita, I'll give you license to, let's say, this cream, which I have a patent. But then, if you want to buy, let's say, a blusher or a lipstick, you will not go to anybody else, but you will buy it only from me. And that lipstick or that blusher is not under a patent. So this is a kind of a restriction that the patentee is trying to put on the licensee, that beyond or besides the patented product, any other non-patented product also you will not buy from anybody else, but you will come to me. So this is one restriction. Okay. Imagine that patentee has patent on bolts. So we have nuts and the bolts. Bolts without nuts cannot work, and nuts cannot work without a bolt. These are like together we need them. Imagine that on bolts, patentee Y has a patent, and licensee comes to him and he says, okay, um, give me your patent or license me your patent for the bolts. But then what Y is saying that, okay, I'll give you bolts, but the nuts which are not under the patent, you have to buy it only from me. And he is selling the nuts at 10 rupees, while the nuts are available in the market, let's say, for 5 rupees. Now it is very wondrous condition, right? Um, because if I could buy some product at less amount, half the rate from a market, the patentee is not allowing me to do, because he will not grant me a license to his patented bolts unless I buy nuts also from him. So this is the kind of a restriction that is being talked about here in the question. So this is how you have to imagine the fact, and you have to link it with some examples so that you can better deliberate and then give answer. Second condition, which is looks like a restrictive condition, which is exclusive grant back. So those who do not know the meaning of exclusive grant back, का क्या मतलब होता है? इसका मतलब ये होता है exclusive. Exclusive mean only to me. Grant back mean granted back to me. What is it to be granted back? Okay, so this is to be granted back. What? So if I have a patent and I give it to you as a license, if you as a licensee make certain improvements on my patent, on my invention, those improvements you will license back only to me and not to anybody else. Now, why are these grant backs listed in the contracts usually? So that the licensee does not become a competitor to the licensor, meaning licensee does not become competitor to the patentee. Because what has he done? He has made improvements on the basic invention, on the main invention that belong to a patentee. So exclusive grant backs are generally there in the contract. But the question is that when I am saying you that exclusive grant back looks like okay, because you are just securing the situation that both the parties, patentee and the licensee, do not end up becoming competitors to each other. Therefore, exclusive grant back is being asked by the patentee. However, there is an assumption now that you have to do. What you have to assume is that the exclusive grant back condition runs beyond the term of a patent. So let's say your patent is going to expire in 2 to 3 years and you are now giving a license to somebody else, and the contract has a exclusive grant back condition under which the patentee is saying that even after my patent has expired, whatever inventions or further improvements you do, you have to grant it exclusively back to me. That condition looks very wondrous. So certain conditions you have to assume. So this is where you can assume this condition. So two restrictive conditions: buying even non-patented product from the patentee, and second, exclusively granting back all the improvements inventions related to improvements also to the patentee back. So this is the question, and now we need to write an answer. So since it's a 5 mark question, uh, you cannot end up writing an essay, and you have to make sure that you provide your provision of the patent act also properly. So let's go. Let's go ahead. Okay, there is a question. There is a query on the chat, Chetna. Roshan is saying that video is not clear. Roshan, which video is not clear? Is this? Are you not able to see this question which is listed here, or what your problem is? Can you just put it on the chat? Okay. Now let's go ahead. So answer would be like this. As an agent, I think that these conditions are not appropriate. Okay. Being restrictive in nature and highly onerous and should be avoided in licensing contract under section 140 of the Indian Patents Act 1970. So you have given the section number here because this is what was also one of the ask as a part of the question. So you have written this. Okay, so Nimi, Krishna, facts, as you are saying, will not be provided. Of course, see, like you, if you look at this, these are the facts already provided, right? What I have just done here is I have rewritten the facts with certain assumptions. So this is the only question that you've been provided of 4 lines, out of which you have to then understand what the question is asking and make certain assumptions. So this is how it goes, and then you go forward and then start writing your answer. So Ritvik is asking, no, the facts we have to deduce before answering. The light bulb she talked about. Okay, so I was giving you the example of the nuts and the bolts. This is for your imagination. This is for your assumption. Because for you to contemplate what is written in the question and how you can convince the examiner, you might have to come up with certain hypothetical assumptions or situations through which you can explain your answer. And therefore, the part in yellow is not given in the, it's not as a part of the question. Question is only this one where they are saying 2 conditions, which is not to buy anything non-patented from outside, but only from the patentee, and exclusive grant back. And I tried to explain you what exclusive grant back is and how, while exclusive grant back may not be onerous, but it may become onerous if the term of exclusive grant back runs beyond the patent term. Okay, so let's start writing the answer. This is how you write. Like I said, it has to be small. It has to be numbered, like number 1, number 2. So I will start that as an agent. I think that these conditions are not appropriate, being restrictive in nature and highly onerous, and should be avoided in licensing contract under Section 140 of the Indian Patents Act 1970. Now, here are the explanations. Number 1, restrictive conditions imposed. So you have picked up each condition one by one and explaining it. So you will say Section 141A prohibits the patentee from regulating or restricting the purchase of articles other than those that are covered by the patent by the licensee. So here you can, if you have time, very well. If you are very fast writer, you can explain it a bit more. What will you explain it as? You will explain it by giving the example of, let's say, nut and bolt, right? So you are telling to the examiner that, okay, imagine a condition where patentee X or patentee Y owns the patent on the bolt, and he is saying that even nuts you will have to buy from me which are not patented. So this condition that, so this imagination that I gave you, you can give that as a part of your answer here. But if you just put a full stop here, it won't be wrong. It will fetch you good marks. But if you have time left, then maybe you can elaborate a bit more how such restrictive condition could be onerous. Okay. Second is exclusive grant back. So what will you write? As per, so restrictive conditions are written in section 141A, and there is another section on exclusive grant back, subsection, which is 141D of the Patent Act. Such restrictive conditions like exclusive grant back and coercive package license are not held to be legitimate as per this section. So you've very clearly at the outset spelled out that our own Patent Act does not allow these conditions. But you have to then explain it a bit more. Thus, such agreements are held to be are treated as void ab initio. What does it mean? That right from the beginning, if it is proven that your exclusive grant back condition was very onerous, that contract itself, that license contract itself, will be considered as void ab initio, meaning void right from the initial time. Then you are explaining a bit more. Exclusive grant back is a provision in licensing agreement under which the licensee is required to disclose and transfer all improvements, including related know-how acquired in the licensed technology to the licensor back. What I explained you, I just explained in the text also here. Such provisions may be counterproductive and onerous in certain conditions, such as if the term of the grant back license agreement is longer than the period of the term of the patent itself. So this is how I have just explained it to you. This is how it has to be written. If it's a 5 mark question, maybe first part you can lengthen it a bit more. You can lengthen exclusive grant back also a little bit more. Basis what I just explained you here as a part of the yellow highlight, giving some of the examples to you. You can put those examples as a part of your answer. But mind you, it's 5 mark question. Don't spend the whole time in just writing a theory, and you don't have to convince an examiner with your level of writing. You just have to convince him with the level of your understanding. So this much bare minimum is good enough an answer. Whatever extra you can write will totally depend on the time that you have in your hand. But let's say you're writing 5 marks question, you should not take more than 5 minutes, 6 minutes to write it. Okay. And then proceed to the next one, because time is really an essence. People are not able to complete their paper two just because it's subjective, and they are not able to address to all the questions. And like I told you last Sunday webinar, and the link is already there in the description, you can re-look into it, where I very clearly told you that in order for you to fetch best marks in paper 2, you have to attempt the question paper completely. You don't leave anything unanswered. So you need good time. Okay. Now let's go to the next question. This is the question paper 2010, and this was the 10 marks question. Okay. So 10 marks means double the size, and you have to explain much more. So let's look at the question first. Your client Karimin has developed a complex electromechanical device for fishing in lakes. His device is able to sense the movement of fishes and then adjust the angle of the bait to effectively attract the fishes. That's his invention. After filing the complete specification, Karimin realizes that the mechanism and the programmed chip in the device can be used for various other applications. So that means he's very clearly spelling out here that when is Karimin realizing that whatever he has invented, it can be used for other applications also. He is able to realize it after filing the complete specification, which means, so this is the catch here, which means when he was writing the complete specification, he was himself not aware about these other applications, these other usages of his invention, which means complete spec did not have support for his additional work. But you might have to assume certain things as we go forward. So the question is, how would you protect all the features of the Karimin's invention? So the question is, any uh, so the additional features, additional work that he has come out with, how will you able to protect it? After a few years, so the hypothesis further goes, this situation further is explained. It's a value-based question. After a few years, Mr. Natoli, a renowned fisherman from Bangalore, makes an improvement on the device. Since you are the best attorney in India, Natoli also approaches you to protect his invention. You find that Natoli's invention is novel but lacks an inventive step. What will be your approach in helping and protecting Natoli's interests. So I hope you have understood the overall question. Karimeen's invention it is. He has come up with a very good device, electromechanical device for fishing, and after filing the complete specification, there is further improvements. He finds that there are further applications to that work, and he has come to you and he has asked you that okay, protect all my work, the further work also. And what else? What could I do? Then Natoli also comes to you, who has made further improvement on the work of Karimeen. And of course, since it's an improvement, it may not be a breakthrough, but it's novel. And he has asked for your advice. So what will you do? So here is, there could be, this answer may have different options, right? Because basis your assumptions as to what all can be done. So see how I have written the question. Like I said, always bullet it. Here I have again bulleted it in the form of option. So option one will be Karimeen may be advised to amend the complete specification so as to include additional features and applications of the device by filing Form 13 under Section 57 and Rule 81. So you have to mention the form, section, and the rule, and if there is any required fee along with an online filing fee. You can either write the fee if you are, if you have a recollection of that. If not, simply say with an online filing fee as prescribed in Schedule 1 or Schedule 2 of the Indian Patent Act. Now here, like I said, if you remember, here was a catch. Here they said that he realized that he can use his invention for further applications after filing the complete specification. So you might have to assume that maybe in the complete specification he broadly covered about these newer application, but there was no explicit mention because he was still inventing it. Or if that is an assumption that it was in his mind and he maybe broadly covered it already in the complete specification, then it only makes sense for him to file for an amendment. Because if you look at Section 57, you cannot amend the claims if any feature or anything that you put in the claim goes beyond the scope of the complete specification. If the claim part is not supported by the complete specification, then such amendments will not be taken care of. Therefore, you are very clearly telling to the examiner that this amendment in his complete specification he can do and put the better claims only if those additional features were broadly covered in the specification. Which means if they were not, and he just realized everything after filing complete spec and there was no support already, then you cannot go ahead with this particular option. And therefore, you are giving your options to the to Karimeen. Now, what would be this option two? Alternatively, I would suggest that Mr. Karimeen to file a request to the controller to convert complete specification into provisional specification according to Section 9(3) within 12 months of the original filing date. Remember in the class, I told you and we discussed very much in detail Section 9, Subsection 3 of the Indian Patent Act, which means as per which you can convert your complete specification and say to the controller, okay, don't look at my complete as complete, but convert it into provisional specification. What does it mean? And this usually happens when you suddenly realize that, okay, I could have put more details in my complete spec. Huh? If you realize it that you forgot to put something, or you could have made your complete specification even more stronger with lot more information, you can make use of Section 9(3) of the Indian Patent Act, and you can request the examiner to convert your complete specification into the provisional. Since it has been converted into provisional, you get another chance to file one more complete specification, right? But that also has to be filed within 12 months from the date of the first filing. So your answer will be, he will now be advised to include all missing features of the invention while drafting the new complete specification, which has to be submitted again within 12 months from the original filing date. Hence, the new complete specification that is filed later will now protect all the features of the invention. So these are the two steps, these are the two options that you can give to your client Kareem. What is the third option that you can give? I may also advise Karimin to file patent of addition. I remember, see, I request all of you to start putting your own answers also. Don't wait for me to give you an answer. The moment I read you a question, please start typing your answers as to what would you have thought to write it. Only then I'll understand, no? So please put your answers. I know that most of you, when I read this question to you, that he has come up with additional features, more improvements, new applications. Patent of addition only comes and strikes the mind. But people will forget about section 9.3, which gives you an option to convert your complete to provisional and file one more complete with better claims and with better specifications, and also file for an amendment. So the third option is, which may be left and which may be told, is I may also advise Kareemeen to file a patent of addition in respect of the additional features under section 54. Okay, this patent of addition can be filed. Such patent of addition takes the priority from the main application and is granted only after the grant of parent patent application. So there are certain more details that you are deducing, you are telling to the examiner, because 10-mark question is a great way to explain to the examiner that you know the nuances of the Patent Act, and that you have read about the section much in detail. So the answer will be, under section 56, the grant of patent of addition cannot be refused on the grounds that the invention lacks inventive step. So um, remember, like I told you here, it's various other applications. You can assume that various other applications may not have an inventive step, or it may not be a breakthrough. So this is an assumption that you can make. And therefore, your option 3 that you are giving to Kareemeen is to file a patent of addition, right? And this cannot be refused basis the lack of inventive step vis-a-vis the main invention. But he has to still prove the inventive step with regard to any other prior art reference. It would be advisable to file patent of addition if there was no mention about the new application or features in the complete specification, even broadly. So, like taking a clue from here, in option 1, you made one assumption that maybe if there was a broad mention already in the complete, it's better that you go ahead with amendment. But then in option 3, there is another assumption, which means if there was no mention in the complete specification already about these new features, then it is better you go ahead with the patent of addition. So there may be several options that you can give to your client. Now, we are not yet complete um, with the next part, where you have to now give answer to Mr. Nitoli also. There is a question from Nimmi Krishna. She's saying option 2, priority date will be lost, right? So let me reread. No, Nimmi, priority date will not be lost, my dear, because when you have when you have requested the patent examiner to consider your complete specification as provisional, now you're filing another complete. You're actually, this new complete is also taking priority from the initial complete specification only. So you are doing all these activities within a period of 12 months. So you will not lose the priority. Okay, Nimi, is that clear? So now there is another question that you have within the same question. It's, you have to now give answer to Nitoli, who also came up with some improvement, and he very clearly tells you that there is no inventive step in it. So what will you do? So certainly, for any improvement, you cannot file a patent application, because if you file, your Karimeen's patent will become a prior art, and you will not be able to prove non-obviousness or inventive step, which is the very important criteria for a patent eligibility. And this Nitoli cannot file even the patent of addition, because Nitoli was not the applicant for the main invention. It was Karimeen. Patent of addition can only be filed in case of the applicant is the same. But here it's a completely different new entity. So he cannot file a new patent because it doesn't have an inventive step. He cannot file a patent of addition to overcome the issue of inventive step because he is not the applicant. He was not the applicant for the main invention also. So what is the recourse left for him? So this is how I would have answered, is this. Further, since Netoli's invention lacks inventive step and is obvious over the invention of Karimine, hence it will be difficult to overcome the challenge of the inventive step. So this is how you are explaining your reasons to the examiner. Such improvement can be the subject matter of patent of addition in accordance with section 56, where an application for a patent of addition cannot be challenged on the ground of inventive step with regard to the disclosure of the main application or main patent. However, Mr. Netoli cannot file a patent of addition as he was not an applicant with respect to the parent application also. It was Karimeen. So it is Karimeen who is the inventor of the main patent, main invention, and is only eligible to file patent of addition. So for Netoli, बेचारा उसके लिए तो there is nothing left. But there has to be something for him, right? So what will happen is that Mr. Notoli can do the following. He can either sell his invention to Karimeen or assign his invention to Karimeen or gain a royalty on mutually agreed terms. Karimeen may then decide to file patent of addition in his own name for that improvement because he has taken the assignment. He has been assigned that invention by Anatoly. This is one thing that can happen. The other thing that can happen is that both Nitoli and Karimeen can enter into an arrangement with each other whereby Mr. Karimeen can file a patent of addition for such improvement where he lists Mr. Nitoli as one of the inventors. Now, para 1, form 1, para 2, para 12 declarations as to assignment of invention should be made. Now, if you recall, and I'll show you in the next slide, that whenever you have got assignment of the invention from some other party, you have to produce that assignment deed and give it to the patent office and attach it. And when you're filing any application, let's say you file a patent of addition, Karimeen files a patent of addition here, files a form 1, then there is a declaration that he has to give that he has been assigned that invention and that the other party is true and the first and the true inventor. In such case, the arrangement and assignment deed will have to be presented to patent office for an entry in the register of patents. Okay. So this is form 1, declaration, para 12, 1. Declaration by the inventor. So what is inventor? Here it's giving in case the applicant is an assignee. So here Karimeen is an assignee. The inventor may sign herein below or applicant may upload the assignment deed with this application for a patent. Now what is he saying? I, the above named inventor, which means Nitoli, is the true and first inventor for this invention and declare that the applicant, Karimeen, herein is my assignee. And then he puts a date, signature and his name. And then within form 1, para 3, 12 declarations, para 3 has to be also given by the applicant, which is by Karimeen. So what is the declaration that Karimeen has to give? I, the applicant, hereby declares that number 1 box he has to tick, that I am in possession of the above mentioned invention. Then second he has to say is that the complete specification relating to invention is filed with this application because patent of addition has to be in the form of complete specification. It cannot be provisional. Then he has to also click this part. See that I am the assignee of the true and first inventor. So this is what he has to provide. Okay. So this is where your invention, your answer will be complete. Certainly, you don't have to write this in the answer. You cannot memorize everything about different forms. But all I've just pasted this for your information. That when you are putting it here, that Nitoli and Karimeen are entering into an arrangement with each other. This is how they'll have to give Form 1 Para 12 declarations. Okay. So this is the end of the question 2 for today's discussion. Then we go to the next, but let me just pick up some questions. Sunshine Nature, I don't know, the name is missing. It says regarding option 1, amendment can be made only in view of the disclaimer, correction, and explanation as per section 59. Then, can we give still this suggestion option 1 from, okay, this is Anjali. See, Anjali, you are very right. You are absolutely right. You can only make changes with regard to the, like you rightly said, in terms of this, the disclaimer, correction on or explanation. But where are you making these corrections, right? You are making these corrections in the claims. You are making these corrections in the specification. And you, if you have some on ground experience, you would note that you have to color mark and say that, okay, I'm deleting this part and adding the new portion. So you can make those changes. So you can still convey. But like I already said, it is quite apparent from the question that we realized about all of this only after filing the complete spec. And complete spec did not have even broad coverage. But you are still assuming, right? There are certain assumptions that you have to make. In light of those assumptions, you can still give as an option, right? This option won't be incorrect because many a times it happens that later on amendments are filed and corrections are done to the complete spec also, and certainly to an extent in the claims also. However, the only catch is that the scope of the claim, the newly added claim or newly corrected claim, should not go beyond the scope of the specification. These both should support each other. Okay, is that okay, Anjali? um, there is another question from Karthik. Can inventors of patent of addition and original application be different? Karthik, yes, inventors can be different because if you would have seen, many a times two multinationals work with each other, or two institutions work with each other. For the main invention, there were some other inventors, but for the improvement, they might have taken more inventors from the other company. So for inventors may change, existing plus new can come. The only catch for patent of addition is that the applicant has to be the same. If it is Karimeen for the basic, for the main invention, it has to be Karimeen, same applicant for the patent of addition also. Inventors is not an issue. Sarbani is writing, Mr. Natoli can seek for a license and then files a patent of addition. Absolutely, Sarbani. Very good answer. That is why I also wrote here, Mr. Natoli can do the following. And I'm happy that you wrote this even before I presented my answer to you. So you are going on a very right direction. So he can either sell, assign, take a royalty, be an inventor for the further invention. So he can do all of that. Okay. So good. Thank you so much for for writing your answer. Ritvik is saying, I guess applicant has to be the same. Yes, absolutely, Ritvik. For patent of addition, only applicant has to be the same, but not the inventors. Inventors may change. Okay, let's go ahead, guys. Um, this is a very interesting question. Okay, and I'm sure most of us will have uh, change in the difference in opinion, and I request you to post your answers here as to what you think. Okay, so here your client X writes to you as follows. What is he writing? Our Indian patent issued in December 2009 describes and claims a process. Okay, so the patent is a process patent of reacting A with B under certain specified conditions. Some specified conditions not mentioned here in the question paper. However, it says that A plus B under specified conditions gives you C. Okay. It is also essential. So this is an essential, it's an inventive concept, feature, that catalyst Q be present in order that the product C may possess the desirable characteristic, which means when A plus B reacts under certain conditions to give you C, this C should have some desirable characteristics which you only get only and only if catalyst Q is present. Okay, outlined in our disclosure. So, unfortunately, none of the claims in the patent makes any reference to the catalyst Q. So, it's there in the description, but it's not in the claim. So, the inventive concept, inventive feature was missed out in the claim, which was actually giving C the desirable characteristics. So none of the claims in the patent make any reference to catalyst Q at all. even though catalyst Q and the manner in which it is used in the process is clearly described in the disclosure. It's there in the spec but not in claims. We would like to take an action in near future against a competitor of ours who has been using our process for last 1 year. Do you think we will have difficulty in enforcing our patent? And if so, is there anything you can do to improve our prospects for success against the competitor? So this is a catchy line. Therefore, I have highlighted it in different color and I've underlined. Most of the answer you will get from these two statements itself. What? Do you think there will be difficulty in enforcing the patent? So the question itself is asking you that if there is an infringement now happening, can you take him to the court of law and will you be able to prove that infringement? So the here examiner is not asking you for a direct yes and no. He is not asking you to prove a point whether there is an infringement clear cut or no infringement. Okay. He's just asking you, would there be a difficulty? What is your thought process? And if so, so this is the next catch. If so, so examiner himself is giving you such a big hint in the answer that if so, there is a difficulty or there is going to be difficulty, what can you do to improvise the prospects for your success against the competitor? So he has himself giving you a lot of a big hint that whether there'll be difficulty or not, and if yes, then what is it that you can do to make it better so that you can take him to the court of law at a later stage. Now, Jayashree has written no, and then she writes, yes, we can prove. Jayashree, can you be a little bit more explicit? What is it that you can prove? Are you proving infringement or are you proving no infringement? I want each one of you to write answer. So one question is advise X. Advise X on what? Do you think there is a difficulty in enforcing? And if yes, what can you do? Or how can you help uh, to make it better as a success rate if he wants to go to the court against the competitor for infringement? So let us just focus on this one question and let's not go to point number 2 and 3 still. You just have to advise X on these 2 points. I want to know whether you think this is an infringement or not. Jayashree, please write your answer. Sarbani is saying the competitor is actually infringing. Okay. So Jayashree, can you please also write why you think that the competitor is infringing? What makes you think there is an infringement? Okay. Then Jayashree is saying no difficulty in enforcing. No difficulty in enforcing. So Jayashree is also saying that okay, I can enforce because so maybe Jayashree, you are trying to say that there would be an infringement, right? Um, Another answer is infringement because of the prior publication. Okay, anybody else? Karthik, Kshitij, Rajesh, Dipali, another Sarbani, anything that you want to say, Deepa, please mention your answers. I want to understand from you what is your understanding of this. Is there an infringement or not? See, there is a clear, very big hint that would there be difficulty, and if there is a difficulty, what can you do to improve the prospect? Because if there was no difficulty, I think the second part of the question would not have appeared. Okay, if it was so clear cut the case. So Usha is saying no fair basis of disclosure with the claims. Yes. So Usha is standing differently from what others are saying. And Karthik is saying it will be difficult in enforcing a patent. It is advisable to move for the amendment. Okay. See, you guys are just giving me answer of yes and no, but you're not explaining your answer. Because when you write an answer in the exam paper, you cannot just say yes and no. You have to explain to the examiner why are you saying it like that. Aman is saying counterclaim for revocation can be a threat. Yes, absolutely, Aman. Because if you file for an infringement suit, there will certainly be a counterclaim that it's invalid. And I want to know from you, Aman, why do you think this counterclaim will sustain? Vipul is saying no infringement as each component is not claimed in an independent claim as catalyst is missing. Vipul, I would like to be your devil's advocate as I go to the next slide. I will stand both the sides. One time I will prove that it's an infringement. I'll try to prove it's an infringement, keeping in view myself in the shoes of a patentee. And I will also put myself in the shoe of the infringer, alleged infringer, and I'll try to prove why it is not an infringement. So you have to contemplate your answer from both the perspective and then say which weighs more and then write your answer. Rajesh is saying no, there is no infringement as it has not been claimed. Rajesh, um, the infringement, whenever you look at it at an infringement, you have to match each and every essential feature with the uh, with that of the infringing process or infringing product. Okay, if all the essential features are matching, no matter what is additional used will not matter. Anyway, let's go ahead. Jayashree, pre-grant amendment, let's not go to pre-grant yet. I just want to ask you one question. Is there an infringement? If not, why? If yes, why? Okay, so thanks for all of you for giving me your answers. Let's go ahead and let's look at the let's do some brainstorming. So these are the two questions. Do you think there will be difficulty in enforcing patent? In this question, the paper setter is not interested in knowing whether there is a clear case of infringement or not. Okay. Second is, if so, is there anything that you can do to improve the prospects? And this is a big hint in the question paper itself. That examiner is himself giving you a hint that there will be a difficulty. But let's not go by that. Let's use our own brain and think about how our brain as a patent agent thinks. Okay, Vijay Lakshmi saying applicant can amend. Okay, let's not go to amendment yet. We are still just contemplating whether there is an infringement or not. Let's go ahead. Okay, let's brainstorm. Okay, first thing that you must remember is that anything that is not claimed is disclaimed. So this is A plus B under specified conditions give you C. This is the patentee's claim. And patentee also says that in order to get this C in a desired characteristic, you need to have catalyst Q, which is missing in the claim. See, I have not written here. So C will come out to be C only if there is a catalyst. What is the alleged infringer's process? So it's a process patent. What is alleged infringer doing? He is using A exactly. He is using B under the same specified conditions as in the process patent, which is giving C, but he is using catalyst Q, which is not claimed. Now looks like an infringement, right? It looks like on the face of it there is an infringement. Why? Because all the elements of the claims are present in the infringing process also. How? See, patentee's claim has A, alleged infringer's process also has A. Patentee's claim has B. Alleged infringer's process also has B. Under specified conditions, here also he is using the same. And C is matching. Here he is giving C. Here alleged infringer is also getting C as a product. Okay. So all the four essential elements are present in the alleged infringing process also. So looks like there is an infringement because at least all the features of the claimed invention are present in the alleged infringer's process also, right? But here we must take a pause here, and let us see whether if Q was not there, do you really get C or is it C dash? Let us just move ahead. Is the patentee in the possession of the invention or not? This is the question. See, if you look at Form 1, Para 12, Part 3, we just saw you have to prove that the patentee is in the possession of the invention. Are you possessing the invention that you are claiming, right? Look, he is saying A plus B under specified conditions give C. Okay. Now, is the patentee already able to possess C? I guess not. Why? Because Q is missing. Without Q, it will not be C, it will be C dash. So what does it say? Without catalyst Q, the product C in the claim process will not have characteristics as desired. Thus, without Q, the resulting product as per the claim process would rather be C double dash. Isn't it? See, now look at A plus B under specified condition is actually giving you C double dash and not really C. Because if you were to get C, you should have put claim in the part of the claim as catalyst Q also. Without catalyst Q, you cannot get C. It has to be some other product then. So what is alleged is now allegedly infringing process matching. Okay, A is matching with E, B is matching with B. Under specified conditions is matching, but C is not equal to C double dash. Because this person, an infringer, is using catalyst Q, which was missing here. So these are the two things, right? It looks like an infringement. It is an infringement. if you look at only these essential features. But if you further drill your brain further, then you will find out it may not be, because this C's will not match. And therefore, as a patent agent, it becomes your duty to give entire clarity to your client. Now, how will you write the answer? Okay, you will write the answer. So, this is assume X's invention has not yet been patented, um, but is merely the subject of the 1 second. So, there is an assumption that you are making. This assumption is that X's invention above has not yet been patented but is merely a subject of a patent application before, but you don't look at it for now. There are two three assumptions that you can make. Right now it is very clear that the patent is granted already, and whether there is an infringement. Okay, these are the another set of two questions. We don't want to go through it right now. We just want to brainstorm only on this first part. Let us look at the answer. So, do you think we have a difficulty enforcing our patent? And if so, is there anything that you can do? So, this is your advice with the X to the X will be. At the outset, I would like to mention that catalyst Q represents the inventive step, and hence its presence is the key element in getting product C with desired properties as described in the specifications. Unfortunately, an essential element Q, which is required to possess product C, is missing in the claim. So you are actually not in the possession of your invention which you are trying to claim because of that minus of that uh, catalyst Q in the claim. The infringement is to be seen with respect to the claimed elements or claimed features. While the competitor is using the process, using the elements described in your claimed invention, and hence infringement action may be undertaken. However, it will be difficult to prove an infringement on the following grounds. So you're not saying no to infringement. It looks like on the face of it there is an infringement, but proving an infringement will be difficult in the court of law. Why? And you're giving your answers in bullets. Again, I told you to write it in bullets 1, 2, 3. So this is how you will write. The product C being produced through a claimed process would not possess the characteristics as described in the specification, as the key element Q, which gives C the desired properties, is missing. Hence, the product C of the claimed process would rather be just considered as product C double dash and not exactly C. Therefore, the product C of the competitor will be considered as different from the product C double dash as claimed in the process patent. Thus, while reactant A and B are common in both the claimed invention and allegedly infringing process, however, the final product C would not match. So, proving infringement in the court of law after you have filed a suit will be difficult. This would imply that process adopted by competitor C is not the same as that of the patented process. What is the second point you are giving? Therefore, enforcing patent would be difficult. Even if the infringement action is filed, it would be a weak claim. It is expected that the competitor would rather file a counterclaim, like Aman's just said, that it is expected that competitor would rather file a counterclaim on the grounds of Section 64I, on the grounds that, what is Section 64I? It says that the scope of any claim of the complete specification. So you are reading the claim, and the scope of the claim is not sufficient. It's not sufficiently and clearly defined, or that the claim of the complete spec is not fairly based on the matter disclosed in the spec. So your claim is not being supported by the spec here. You have missed out the essential element, so you are not in the possession of it, and also it may be revoked under Section 64I. In order for you to improve, now here is the answer you are giving to the second part. Now you have proved your first part. Whether there will be enforcement difficulty, yes, there will be difficulty in enforcement. Now, what can you do further to improve? This is what you can do. In order to improve the prospects of success against competitor, it's important that that first the amendment is filed, and later, once the amendments are admissible, they are admitted, then the case of infringement is filed. Then that will be a good infringement suit. The fee for filing such amendment would be a bit higher, as the patent has already been granted, and the fee will be as per the Schedule 1 of the Indian Patent Act. This is your answer to advise X on these two questions. Okay. Aman is writing ideally X should first file the amendment. Yes, Aman. That's what I just said as point number 3. That in order to make your better claim of infringement, first file an amendment, then go ahead. Let's go to the other two questions. The other question that examiner asked you is, now assume that the excess invention above has not yet been patented. It's still in the application form. Would your advice be different now? Consider both situations where application has been published in the official journal, where it has not been so published. So now it's just an application, it's not yet been granted. You can easily, what you can do is, since it's not published, you cannot file for a claim for infringement, right? I missed to write it here, I guess. Therefore, you have to start with writing that since it's just an application, patent application, the suit for infringement, enforcing your patent would not be enforcing your rights will not be possible right now, because your rights have not yet been accrued. Your patent has not yet been granted. So therefore, you'll have to wait for the patent to get granted to take the potential competitor to the court of law, and then you will write this. I would advise Mr. X that since the application is under prosecution and has not yet been granted, he can rather file the amendment by filing Form 13 along with the prescribed fee. And this such amendment can be done before the grant of a patent under Section 57. The fee is certainly less because the patent is not yet been granted. Therefore, these amendments will make excess patent strong, and he would be able to enforce his patent adequately against the inventor upon its grant. So this will be your answer. There is a third question which says, assume now that the letter above is worded differently. It indicates that excess addition of catalyst is an improvement which is not included anywhere in the specification. What would be your advice? So here it will be a clear-cut case of infringement, right? Because here X is not really an inventive step required for C to be there in a particular with particular characteristics. Okay, since Q is just an improvement now, there is a clear-cut case of infringement, and in this such cases, proving infringement would just not be difficult. So, but your answer with regard to if this is just an improvement, what will you do is, in case the addition of catalyst Q is just an improvement, it is advised to file patent of addition under Section 654, and then you can just elaborate a bit more about patent of addition like we did in the previous answer, that it won't be granted before the grant of a parent application. Its priority date will be the same as that of the parent. It will expire on the same date as that of the parent, and that inventive step will not be seen. So this is how your answer will be. It's 10:03 sharp. I think we should close it here, and there are a couple of more questions which I wanted to take for today, but let's not go beyond our 1 hour schedule time. But you must become part of the community, because IPTSC Academy will come up with further such webinars, almost 1 or 2 in a week's time, every week. So you must join a Telegram group, and I think Chetna from IPTSC Academy must have posted the link to the Telegram group. Also subscribe to this channel so that whenever there is a next webinar schedule, the free webinar, you'll be able to get it. And also, the classes will start by IPTSC Academy from 12th March onwards. By all means, you guys are more than welcome to register for it. I'll be the honorary course instructor, and we'll be happy to work with you together to help you crack the exam. But I think with this, we can close today's session. Let me put it on stop sharing and see if there are any questions. So Aman is saying that. Aman is saying, would even Section 64H be attracted for revocation, considering the best mode is not given in the claims, or does the mention of Q in the description constitute best mode and protect against the same? Yes, Aman, this is a very important point. I think Section 64H can also be listed. The only point is that the method is already described much in detail in the specification. The best mode enablement is there in the spec. It's only that it's not there in the claim. But there'll be no harm if you write it. in your answer. So I think that is it for today. And next one we will look at the rules and how to respond to the answer related to IPAB. And let's see when we can do that next. I think we can close this session now. Thank you so much. It was great to see you all, and thanks for interacting for this. Thank you. Take care, everyone. Good night. Sleep well, sleep tight, but wake up early morning and start doing your studies again.